Good morning. Welcome to the May docket of the Tennessee Court of Criminal Appeals. Today's arguments are going to be live streamed, which is a new process for this court. Before we begin, let me introduce you to the panel. To my left is Matthew Wilson from Madison County. To my right is Tim Easter from Williamson County. And I'm Bobby Holloway from Murray County. As you probably know, oral arguments are 20 minutes per side. If the appellant wants to reserve some time for rebuttal, let me know at the first of your argument. We will also be using the timer. Is that correct?
Yes, Your Honor.
We haven't used that before, so it's going to be a new experience for this court also. Judge Easter's on this case because Judge Ayers had a conflict. She will be coming in for the next three cases, so we'll be taking a recess after this case. Are there any preliminary announcements?
No, Your Honor.
I call the first case.
State of Tennessee versus Anthony T. Brown.
Good morning.
Good morning. Thank you, Your Honor. Glad to be, the guinea pig today for the timer and the streaming. I would like to reserve 4 minutes for rebuttal, if I may. And my name is Mitch Raines. I'm with the Public Defender's Office, and I represent Mr. Anthony Brown this morning. I've raised two issues on appeal. For the purposes of argument today, though, I'll only address one, and that's the lower court's error in appointing a substitute judge. We're dealing today with Tennessee Supreme Court Rule 10B, which governs the interchange process amongst judges when they need to recuse, whether they have a conflict, something of that nature. And as the name indicates, it's established by the Tennessee Supreme Court. This Rule 10B essentially lays out a phone tree, if you will, on who a judge needs to call when they have a recusal. And in matters such as this, where the presiding judge is also a recusing judge, the proper procedure is for the presiding judge to contact either a presiding judge pro tempore, and if there's not one of those available, then the Chief Justice through the AOC. And there's even a form that's provided in Rule 10B for them to fill out and submit. And then at that point, the Chief Justice selects a successor and the case moves forward. Rule 10B also provides that a recusing judge shall have no input in the selection process of another judge.
In this case, though, the recusing judge is not the presiding judge, correct?
It is the presiding judge. In an order dated October the 19th, which is the only order of recusal that exists in the record, and we've supplemented with docket notes to show that the first arraignment on the 16th, it appears that Judge Ayers, trial court Judge Ayers at the time, pulled off of the case. But Judge Olita on the 19th issued the only order that we have in the record, stating that Judge Jill Barty Ayers and all of the circuit court judges in the 19th Judicial District recused themselves.
But doesn't that make Judge Ayers the recusing judge?
It makes all of the judges from the 19th Judicial District recused judges, including Judge Olita, who is the presiding judge. If the language had been different there, then I think that there might be an argument to say that it was only Judge Ayers, but the record as it is and this order as it stands is that Jill Ayers and all of the judges recused, including Judge Olita. It doesn't say why she recused as the presiding judge as well, but it is all-encompassing. It includes Judge Olita as a circuit court judge of the 19th Judicial District.
Can we create a clear time frame of the occurrence of events based on the record that we have before us?
As far as recusal, yes, I believe so. The docket notes indicate that on October the 16th, I believe, that was the initial arraignment. That's when Judge Ayers indicates that she's going to recuse from this matter and also appoints the public defender to represent Mr. Brown. And then on the 19th, we have this formal order of recusal entered by the presiding judge, Judge Olita, that again includes all circuit court judges.
But isn't that exactly what the rule requires? The trial judge says, I'm out. presiding judge then gets involved, puts down an order, identifies somebody from another district?
If the presiding judge was not also recusing from the case, then yes, that would be correct. But Rule 10b makes clear that if the presiding judge is the recused judge, then the presiding judge shall take no action in selecting a successor. So because all of the judges recused themselves, the proper procedure would have been for Judge Alita to reach out through the AOC to the Chief Justice for the appointment of a judge.
Would you agree with me that one reading of the October 19th order is a form of simultaneous action, that having all the judges having recused themselves, like it's happening right then, this judge in the 18th, Judge Gay, will be appointed?
It does cover both of those events. It, in one breath, recuses all of the judges from the 19th Judicial District, including the presiding judge, and then at the same time, it designates Judge Gay as the judge to handle the trial court, or to handle the trial. That's the...
Go ahead.
Sorry, I was going to say that's the problem, that Judge Alita recuses, and in the same pen stroke also appoints Judge Gay.
Well, obviously, someone had contacted Judge Gay, or it appears obviously, someone had contacted Judge Gay before the 1019 order. And I assume it was Judge Alito. I'm just making some assumptions.
The record does indicate that through Judge
We've got
Gay.
some conflicts here. Will you do this? He said, I will. She then puts down an order, and she, I don't know how the conversation went, and I don't know if any of that's in the record. And she then puts down the order. By that time, all the other judges recused too. So at the time she contacted Judge Gay, is there any indication in the record that she had already recused or decided to recuse herself?
It is in the record from the motion for new trial, I believe, or it may even be the pretrial motion addressing this issue, because Mr. Brown raised it at 2 points below, where Judge Gay says basically that he was contacted by the presiding judge, said he didn't have any conflicts and was happy to hear the matter. So that is in the record. When all of the other judges in the 19th Judicial District recused, it's not in the record specific date and time when that happens, other than October the 19th of 2020, when this order is filed by Judge Alita, again recusing Judge Gilbarty Ayers and all of the circuit court judges.
I mean, I'm sure Judge Easter, likewise. I have been involved in this type of situation as a trial judge, where one of the judges has a conflict. And if I was presiding judge, I would usually contact someone in the 21st, our adjacent district, and get Judge Easter and then Judge Bivens, somebody to come down and do the case. And then I would put down an order. And by the time I put down the order, I might realize that none of the judges, including me, really want to handle this case. The person's well-known in the community or whatever else. And so an order goes down recusing everybody important, say Judge Easter, to come down to Maury County and hear it. But it had already all been done before the order goes down. That's sort of what the time frame I'm interested in.
That other than it's 3 days. You have an initial appearance at arraignment on the 16th, and then by the 19th you have all of the judges have recused and Judge Gay is appointed. So the only thing that we can say from the record is that a conflict existed clearly amongst all of the circuit court judges, or else they wouldn't have all recused themselves. And at that point, the Chief Justice should have been brought into the process to appoint a successor. I understand the dynamics of you want to try and figure it out, that sort of thing, but 3 days is a quick turnaround when the simple answer is if the presiding judge is recusing, then contact the Chief Justice to appoint a judge. And I understand that maybe in practice that doesn't always happen that way, but this is a rule from the Tennessee Supreme Court. This is something that they have thought out, that they have laid out. It is detailed in the procedure. It starts with step 1, and if you can't complete step 1, you go to step 2, and so on, until a judge who is qualified and conflict-free can be found to hear this case. And to ignore that process out of convenience or even efficiency would undermine the authority of the Supreme Court. They've said that these rules need to be followed. And in this case, it would have just been simply contacting the the AOC, the same way that Judge Gay was contacted. There's a form that you fill out, you submit it, and then the Chief Justice finds a judge who's able, willing, and ready to take the case.
And I guess that's kind of where I want to get to as well. This whole idea of the string of cases that tell us, okay, the rules were not followed precisely. I never, in the cases that were in the briefs, I don't recall seeing the phrase harmless error, but it seems like it's sort of a harmless error kind of analysis that at the end of the day, when you got somebody who was shot 6 times, viewed by 5 people, the result is going to be the same. It didn't make any difference.
Well, I think this is a structural error, in that a rule from the Tennessee Supreme Court is exactly that. It's a rule from the Tennessee Supreme Court that must be followed. And in the vast majority of cases that have dealt with this, prior to maybe the one from the 1800s, almost all of the participants, whether they be plaintiff, defendant, state, criminal defendant, acquiesced in the successor judge hearing the case. And in the Farrell case, which is from the Tennessee Supreme Court, we have a definition of de jure and de facto. So essentially, I view this as kind of like a 2-step process. You have an issue with whether or not a judge can hear a case. Are they de jure or are they de facto? If they're de jure, then they were elected to the position, appointed by the government, something along those lines. If there is some, and then everything can move forward. If there is an error in how that judge came to hear this case, then you need to analyze whether or not they are a de facto judge. And the Tennessee Supreme Court has defined that as a de facto judge is one acting with the color of right and who is regarded as and has the reputation of exercising the judicial function that he assumes. And they also provide more context and more detail for what a de facto judge is by stating that the judicial acts of one in possession of a judicial office created and in existence by law under color of right, assuming and exercising the functions of such office with a good faith belief in his right to exercise such authority, and involved and acquiesced in by the parties, the bar, the court, and officials, and the public are those of a de facto officer. Here we have clearly an issue with not all of the parties agreed for Judge Gay to take over this matter. So I would say that in and of itself means that he was not acting in a de facto capacity. There's a lesser argument to be made about whether or not he was acting in good faith, because at the motion hearing, Judge Gay does acknowledge that it's likely that the procedure wasn't followed, but we would have essentially reached the same result anyway. He probably would still have heard the case.
When you say the motion
he
hearing,
assumes.
that statement was made at the motion for new trial, or was that made pre-trial?
I think it was made pre-trial. I would have to double check that, but there was a pre-trial motion challenging Judge Gay taking over the matter, and then it was also raised again at the motion for new trial. And I think that comes from the pre-trial hearing.
He made a statement that the result would be the same, that he would be appointed judge?
Yes.
Or that the defendant would be convicted?
No, that more likely than not, he would have been the same judge.
Okay.
There's no further explanation as to how or why that would have been, just Judge Gay's thoughts on the matter. But even then, you still have to have, and again, the vast majority of the cases that have analyzed this issue, and most of them are from the Court of Appeals, unfortunately, say that there's essentially no problem here because at the end of the day, the parties all acquiesced in that judge hearing this case. This court has addressed this issue on substantially similar facts as this one in Lloyd versus State. That's a case out of this court from 2016. And there, you also have a murder case. You have Mr. Lloyd enters a guilty plea to 2 counts of murder.
Do you think it's significant that Lloyd is a post-conviction matter where a judge had, the issue is going to be voluntary plea, I believe, whether or not the plea had been entered voluntarily?
I don't think so. The court also found that there was a viable claim under post-conviction, and then also specifically addressed that the mandates under Rule 10b were not adhered to. And in a post-conviction claim, a defendant has an even higher burden than they do at trial, right? So to say that this issue needs to go back and be dealt with properly on post-conviction, where all things stacked out are against a defendant actually succeeding on a post-conviction claim, as opposed to whether or not a state can carry its burden at a trial, I think makes it all the more important to follow the process at a trial. And this court has said that it has to be followed at a post-conviction claim. So I would think that it would be even more important to follow it.
Did you find
during a
any
jury
other case
trial.
besides Lloyd, Judge Wood's case on the post-conviction, that reversed and remanded based on a procedural problem with the appointment of or the designation of a successor judge?
I have read a lot of cases for this one, and many of them are from the Court of Appeals. So I don't think that there's another case out of this court that as clearly addresses the mandates of Rule 10b and the need for, or not the need for, but that a remand is proper with instructions to adhere to the mandates of Rule 10b from this court. The Court of Criminal Appeals appears to have addressed this issue many more times, but there, the vast majority of those cases are resolved because the parties have agreed that the judge, who normally would not be qualified to hear the case, can in fact do so.
Do you know when this designation procedure was passed by the Supreme Court, the rules?
I don't, Your Honor.
I mean, I've practiced for a long time. You just called anybody you wanted to.
I thought, somewhere in your reply brief, I thought you said 2012.
I would trust what I wrote in my reply brief
think
as
that's
to my
what you
memory
said.
today. I see that my time is almost up, so at this point, if there are no further questions, I'll reserve the balance of my time.
Yeah, you have your 4 minutes.
Thank you.
Good morning, Your Honors. Jonathan Wardle here for the state of Tennessee. First, let me apologize for my voice. It is not the dulcet tones that it normally is. Apologize for the hoarseness, especially since we're live streaming. It's unfortunate. Second, I do want to make one very quick apology about something in my brief. It was brought to my attention by some of my colleagues that it could be read in my brief, and there were some questions about this. It could be read in my brief that I was stating that Judge Alita did not recuse herself before the appointment. That's all I was trying to say is, and I think you all have hit on it, the record is not exactly clear about the timeline. That's all I was trying to say. I also probably ought to address, it looks like we're not going to be talking about the horrific facts of this case, which is fine. Since those were not addressed earlier, I will not address them either. One of the last statements made by counsel was that he'd read a lot of cases for this case. So have I. It's been an interesting thing. I think the best thing I could do to help the court here is walk through a couple of things. First, he mentioned a phone tree, and I'll talk about that. And second is the timeline that we do have, and that's very important. On the phone tree, the way that I understand this phone tree metaphor, and I think it's a great metaphor, there's a couple of branches to it. One is if a judge has to recuse themselves, the first branch is the parties can all agree, can all acquiesce in that judge choosing a successor. If they don't agree on that, then it goes to the presiding judge. If the presiding judge can't do it, then you go to presiding judge pro tempore. And if the presiding judge pro tempore can't do it, it goes up to the Chief Justice. Similarly, once you decide whether it's the presiding judge or the presiding judge pro tempore, first they look inside their district to see if any other judge can take the case. If they cannot, then they look outside the district to other districts to see if someone can take the case. And my understanding from the form that's appended to 10B is that they're supposed to look at a contiguous district if they can. It's the state's position that that is exactly what happened in this case. That phone tree was followed precisely. And I want to hit on one particular grammatical issue that I think hits at what we were talking about earlier. The particular language says, this is 10B section 1.04, if the parties do not agree that the recusing judge can select a successor, the presiding judge of the court shall then effect an interchange. If the presiding judge is the recused judge, the presiding judge shall take no action in selecting a successor. That matters. Not if the presiding judge is a recused judge. If the presiding judge is a recused judge, then the phone tree falls apart. The presiding judge would almost, that second prong where you go to outside districts, you would never do that. You'd skip everything and go straight up to the Chief Justice. But instead, by saying if the presiding judge is not the recused judge, it allows for the possibility that which I assume is the most common instance where all the judges recuse themselves, all the judges in a district recuse themselves. I assume that's the most common instance where no justice or no judge in the district can take the case. You would skip going to another district. You would just go straight up. I don't know if that made sense. That was unclear. Let me say that again. If all of the judges in one district cannot take the case, I assume the probable reason for that is they all recused themselves. If that's the case, if it said if the presiding judge is a recused judge, then you would skip the next step, which says the presiding judge goes and looks to the other districts. You just go straight up to the Chief Justice. But instead, it says if the presiding judge is the recused judge, which allows the presiding judge to say, I'm not the one that had this case. I am going to continue my duties to look to another district here. And the phone tree stays in place.
Well, when does this presiding judge, was it pro tem? Is that what they called it? Or?
Correct. Yeah, the presiding judge pro tem. That comes in if the presiding judge cannot do it. So I assume that would be a case where the presiding judge has a conflict.
So the presiding judge is the conflicting judge.
In that case, yes.
In that case.
Yes.
And then you look around among your colleagues and appoint somebody else, and then that colleague reaches out to another district.
Correct, exactly. But if the standard were anytime that all the judges recuse themselves, I mean, the phone tree just has no branches at that point. Once an entire district decides we don't want to hear this.
I want to hear from you on the Foley case. I mean, excuse me, the Houston Foley Lloyd case. The
Lloyd case, yes.
Lloyd, yes.
Here's what I have to say about Lloyd. It doesn't look like the parties argued that case. There's no analysis about it.
It doesn't look like what?
The parties argued that issue. There's no analysis of it. The state conceded reversal on another ground. And so in my mind, I would say it's dicta, except for I assume when it went back they had to change. So it's not exactly dicta, but it wasn't with any analysis. And there's no case that I know of that has followed Lloyd since it's been put down.
Do you see it being distinguishable from this case because it was a post-conviction where the judge who ultimately says, I have a conflict, I guess because he retired, but he has a conflict, he'd put down some preliminary orders and then been involved in the case, made some findings.
Yes, I can see absolutely a distinction. When you asked that earlier, I don't know that the language goes that far, but if you look at the facts, absolutely that is a distinction that this is not dealing with. In fact, it's not in the record, but to clear up the kind of elephant in the room, so to speak, I was able to talk to the prosecutor in this case, and he said that all the judges recused themselves because the defendant's, I believe it was the defendant's father, or defendant's family member, was the foreman of the grand jury, and the judges all knew and liked that individual.
Is that in the record?
No. That's just to clear up kind of this weird elephant in the room, but no, that's not in the record. I'll tell you what else is not in the record.
Well, let me ask you, so is it the state's position that the language in Lloyd about Judge Hollar's recusing herself is just dicta?
The language in Lloyd about
Recusal.
whether it was done properly, yeah. I would like to say it's dicta. The reason I can't say that is because it went back and they had to do it differently because of the order. But as far as the analysis, there just isn't any analysis. I don't think first of all, it's not published. Second of all, it hasn't been followed by any other case that I'm aware of. And third, because there's no analysis, I don't think this court has to follow it.
And fourth, Judge Holloway was on the panel who wrote that opinion.
I am sure there was brilliant reasoning behind it.
You're backpedaling now.
I can't remember last week, much less 2016, so I don't know why I was on it.
If I can address another matter that I think is incredibly important here, I want to read, and I was just reading this morning, Section 1.01 of Rule 10B has a very important sentence, the very first sentence in all of Rule 10B. Any party seeking disqualification, recusal, or a determination of a constitutional or statutory interpretation of a judge of a court or a judge acting as a court of record, here's the part, shall do so by a written motion filed promptly after a party learns or reasonably should have learned of the facts establishing the basis for recusal. Let me tell you what we have in this case based on the doc report that was entered. Excuse me, on September 18th, 2020, it says that there's going to be there was a hearing arraignment is scheduled for October 16th. On October 16th, there is no entry indicating whether there was a hearing or not. I presume there was an arraignment, but we don't have a transcript of the arraignment, and there's no docket entry there. The only docket entry, I apologize, Your Honors. The only docket entry on the 16th is file 360app.pdf was attached. I have no idea what that is. I don't think it was an order based on the other things, but that's it. October 19th, order of recusal received from Judge Alita. And there's a hearing on the 19th, October 19th. We don't have the transcript of that hearing in the record. So the parties would have known on that day that this was happening. And apparently there was no objection. Apparently it was acquiesced to. I think that's significant. I'm going to go on, but I want to point out while we're here that on October 19th, the order entered says that Judge Ayers and all the other judges recused themselves by order dated October 16th. We don't have that order. Again, we have no idea what happened on October 16th. And we don't know. We don't know why the recusal was on 16th and if anything happened before October 16th. We just don't know. But we do know that on October 19th, there is a hearing. There is the order of recusal put down, and there's no objection. On October 30th, it says that there is a hearing. It looks like it's a settlement conference. No motion filed, no objection. And again, we don't have that transcript. On November 13th, another hearing, another settlement conference, no objection, no motion filed. Finally, on November 16th, after settlement conferences have failed, then we get a motion. I don't think on the facts of this case that you can say that that was promptly done. I would argue, first of all.
So you're not arguing waiver. You're arguing failure to follow the rule that it be promptly filed.
I believe the two are similar. Yes, I am arguing you did not follow this rule. And the reason for the rule is obvious. Once you get into that case, right, I mean, you just can't play with the judges like that. Hey, I know you've been presiding at this case, but you know what? I think you did it wrong. I want to talk about another. I'm sorry, Your Honors. I was not coughing as much
You want to
earlier.
get some water? You're
Yeah,
welcome
feel
to.
free
If
to
you
get
wanna-
some.
I will if I cough one more time. And I forgot where I was. Your Honor, I'm sorry, I forgot where I was. What we do have in the record is that he didn't object until November 16th, which is a month after the first recusal order supposedly was filed, almost a month after. It's 3 hearing dates after the, I'm going to get that water.
I think General Watson's.
There. It's 3 hearing dates later. I would submit that, first of all, he didn't follow the order, follow the rule. And secondly, to the extent that maybe you could argue it, well, you've got acquiescence, and I would say, yeah, there is waiver. And finally, we would say there's waiver because the record isn't clear enough to say exactly what happened or how that happened. So I do make a waiver argument, but that's not the only argument to answer Your Honor's question. I want to address the de facto judge issue. As I've said, I think the procedure was followed properly. I also think that we shouldn't even be here on this argument because the procedure wasn't the defendant didn't follow the procedure properly to object. But if we get to the de facto issue, I don't know what else you would have to do to be a de facto judge. You have the typical process engaged where presiding judge calls and you agree. And so he's acting under what he thinks is appropriate authority. He does say on November 17th something along the lines of, well, I think if the presiding judge would have appointed me, or the chief justice would have appointed me anyway. But at the motion for new trial hearing, he says, I'm being approached by Austin Watkins again. Thank you. At the motion for new trial hearing, Judge Gay says the interchange was done properly. So clearly he thought it was done properly. He's not saying, well, maybe it wasn't done properly, but I don't care. He thought it was done properly. And he says, but even if it weren't, it wouldn't make a difference here. But, so he's acting under what he believes, that good faith, reasonable basis. There's no case that I'm aware of other than Lloyd, and Lloyd has no analysis, that would suggest that what he was doing is wrong. And if you look at the Medical Maxwell series of cases, starting with Farrell going up through Medical Maxwell, that became an issue only because repeatedly the courts had said, you can't do what you're doing. And every time the court said, you can't, use a special master this way, the trial courts would change it slightly. And finally, after 3 or 4 times of the de facto judge rule, the appellate court finally said, no, okay, enough is enough.
I had a question about that. So you're saying that under that last scenario, Maxwell, and that it was kind of a systematic problem. Is that your argument, that the whole system was broke and the court had to finally step in?
I'm not sure I would say the whole system is broke, but it is clear that multiple courts just refused, despite multiple cases, refused to realize that what they were doing was wrong.
Okay.
And the court finally said, enough is enough. We're going to have to impose the consequence here where it's sent back. The Jackson case is interesting because it also highlights the way the de facto rule works. In footnote 6 of the Jackson case, it says, future cases would be considered in light of this clarification concerning the interchange of general sessions judges with circuit judges or chancellors. All right? So after Jackson, you could make an argument that, all right, you can't have a general sessions judge sit as interchange for a chancellor and have the good faith, because you've got a case directly saying you can't do that and warning you that in the future you're not going to be a de facto judge. There's nothing like that here. So I would simply argue that yes, the de facto judge rule should apply if there's even any reason to get there.
Mr. Wardle, let me just ask you on the Williams versus Woods, the case that talks about de facto, at least one of them that talks about de facto judges. It said if a judge is acting under color of law absent bad faith. Now, does that mean, in other words, the court has the authority under the color of law as a circuit judge to hear the case, and he's not acting under bad faith as far as his designation as a successor? Is that what you think that means? Or what does the color of law mean? That's really the question.
Yeah, good. That is, I'll be honest, from my reading of the cases, it's not spelled out exactly where this is color of law, this is the good faith, this is the bad faith. But I believe it's, as Your Honor said, you have law that seems to say, this is right, and I'm acting under color of law because I was appointed by what we think is a legal process. The good faith relates to that. I personally think I have it. Right? The defendant makes the argument that, hey, we objected. Well, again, that objection was late, but we objected, so you're no longer acting under good faith. That can't be the rule. If that were the rule, then the defendant could object for any possible reason, and the court would run the risk of having the entire case overturned later. Right? Here, it's if defendant objects and the court says, oh, you're right, this was wrong, but I'm going to keep doing it anyway. Okay, now you've lost that good faith belief. That's not what happened. Defendant objected a month into it after a couple of settlement conferences and hearing dates. And that's totally different situation. Unless there are any further questions, I would like to stop coughing at the court.
We appreciate your powering through.
Thank you.
Thank you, Your Honor.
General Wardle. All right, Mr. Raines, you have your rebuttal time.
Thank you, Your Honor. Just going to try and address a few things quickly. I'll first start off, the state made an argument that in Rule 10b, it says if the presiding judge recuses or if a presiding judge recuses, and I would just focus the court's attention to that word recused. That's what is important because that's what triggers all of Rule 10b. If a judge recuses, then yes, you start at the top of the chain and you work your way down. If all of the judges recuse themselves, which is what happened here, which is also what happened in Lloyd, and again, this court found that there was an error because the presiding judge there was one of all of the judges, recused itself, and also appointed a successor judge, and that was wrong. So recused implies that there's a reason for the court to pull off. And 10b also says that as you're going through this process, you should look to, I believe it's Rule 11, which basically just says that the court, in reappointing another judge within their district or outside of it, should consider basically judicial efficiency. What kind of caseload do you have going on? Is this going to cause problems for your trial docket, that sort of thing. But to recuse yourself because of a conflict, which is what happened in this case, although it's not in the record that's why all of the judges recused themselves, but the state, I believe, is correct when it says that it was because Mr. Brown's father was a longtime grand jury foreman. If you have a conflict and you recuse, and then you also still participate in the selection of the successor judge, then that conflict is imputed, or there's at least the appearance that that conflict is imputed. That's why it's so important to follow the mandates of Rule 10b, is to maintain that impartiality of the court, make sure that everything at least has the appearance and the practical effect of everything is done on the up and up. There's no issues here at all. And Mr. Brown objected. He did file a written notice. There's nothing in the record to indicate when he first became aware of the presiding judge's failures under Rule 10b. I would have to assume that it was in November when he filed his motion. That the process was not followed here. This wasn't an objection to Judge Gay just because there was one being made. There is a legal basis for challenging Judge Gay's appointment here, and it's because the presiding judge also recused and also still selected a successor judge. I would also just like to briefly address, there's this issue of notice, of trial courts need to be on notice that they're not properly adhering to the mandate before recusal can be a proper outcome. I don't know of any clearer notice that this court could have given than Lloyd to say we have an issue where all of the judges have recused themselves, the presiding judge included, also the presiding judge selected the successor, and we are telling you now that that is wrong. And we are saying that when this goes back to the post-conviction court, you have to follow the procedure laid out in Rule 10b. That was in 2016. This obviously was in 2020. To me, that's clear notice. Not even that notice is required, just adherence to the rule is required. And I see that my time is almost out. So at this point, I would just ask that this court recognize the error, find that this should be remanded back for renewed proceedings that properly adhere to Rule 10b. Thank you.
Thank you, Mr.
Thank you.
Raines. All right, thank you, counsel. Well argued, well briefed. We're going to take a recess now and do the tag team and let Judge Ayers come in for Judge Easter. So we'll be back in a few minutes.
All rise. This court is now in recess.